In July of 1862, a domestic servant died in the basement of a respectable terrace in the west of Glasgow, and the cause was recorded plainly as murder. The suspicion fell within a fortnight on the last person in that propertied household anyone had thought to answer for it. The woman later accused of causing that death was Jessie McLachlan. She was about 29 years old, and she was the friend of the woman who had died. She was a Glaswegian of the working class, married to a seaman named James McLachlan, who was often away at sea, and she was raising a young child in modest lodgings in the city. She had once been in domestic service herself, and in an earlier period she had served in the very household at the centre of this case. There she had known the dead woman, and the two had remained close after McLachlan left that service. The record establishes no prior death in her circle, and no prior charge against her name. The case that would be built against her rested entirely on the events of a single night and on what followed in the days after. The city in which these events occurred was Glasgow at the height of its industrial expansion. In 1862, it was a place of shipyards and warehouses, of soot and river traffic, of great wealth accumulating in the western terraces, and great poverty pressed into the closes below. Sandyford Place stood among the genteel rows on the western approaches to the city, a terrace of tall stone houses occupied by professional families and served out of sight by the domestic economy on which such households depended. Behind the polished doors and the drawn curtains ran an invisible labour of servants who slept in basement rooms and rose before the family to lay the fires. It is in that lower stratum of the respectable house, and in the credibility gap between those who lived above the stairs and those who lived below them, that this case must be understood. The distance between an 87-year-old man of a propertied family and a young working-class woman holding a pawn ticket would, in the end, decide who was prosecuted and who was not. The household to which both women were attached belonged to an accountant named John Fleming, a man of business and standing, who kept the house at 17 Sandyford Place. The family also included his father, James Fleming, then 87 years of age, who lived under the same roof. The family kept silver plate in the house, as households of that class did, and they kept 2 servants where the season required. On the weekend at the centre of this account, the family had departed the city, leaving the house occupied only by the old man and by the servant who slept in the basement room. That arrangement, ordinary in itself, placed 2 people alone together in a large empty house for the better part of 3 days. What passed between them in that interval is the question the record has never settled. Of Jessie McLachlan's early life, the record preserves comparatively little, and what it preserves must be reported only as far as it is documented. She was born in Scotland around the year 1833. Her maiden name is commonly given, though the record does not establish it with certainty, and it is safer to say that the particulars of her parentage and childhood have not survived in reliable form. What is documented is that she entered domestic service, as a great many young women of her class did, and that her service brought her at one point into the Fleming household. Domestic service in the Glasgow of that period was the ordinary condition of the respectable working woman before marriage, a station that placed her inside the homes of her betters while granting her none of their security. She would have risen early, worked long, and lived at the sufferance of the family that employed her. It was in this station that she came to know Jess McPherson, who served in the same house. She left that service upon her marriage. Her husband, James McLachlan, was a seaman, described in the accounts as a ship's steward, and the nature of his work kept him at sea for long periods, leaving his wife to manage a household on an uncertain and intermittent income. They lived in modest lodgings in Glasgow, and they had a young child. The financial condition of the household was straitened, and that fact would later be pressed at trial, for the Crown would seek to show that a woman in want had reason to take what did not belong to her. It should be said plainly that being poor is not evidence of murder, and the record does not establish that McLachlan's circumstances drove her to any crime. It establishes only that she was in want, and that the pawning of goods was, for a woman in her position, a familiar recourse in a hard week. Contemporaries who spoke of her before these events described her as respectable and of good previous character, and the campaign that later formed on her behalf would stress that reputation. The record does not supply the fuller portrait a biographer might wish. It does not describe her temperament, her habits, or her disposition in any way that can be relied upon, and it would be a violation of the record to invent them. What can be said is that she was a married woman of the Glasgow working class, in her late 20s, keeping a small household on a seaman's wages, and that she maintained a friendship with a woman she had once served alongside. That friendship, and where it led on a single July night, is the whole of the matter. If you value cases preserved through court records, testimony, and verified documents, follow or subscribe wherever you are listening. The record resumes in Glasgow in the year 1862. The woman who died was Jess McPherson, sometimes written Jessie McPherson, and she was about 33 years of age. She was a domestic servant of good standing who had worked for the Fleming family, and she must be presented here as what she was: a working woman with her own place in the world, her own friendships, and her own good name. She was not a device in another woman's story. She had served in the Fleming household and had made her life in the ordinary way of servants in that city, rising early, keeping the house, and holding to the small respectabilities that her station allowed her. She and Jessie McLachlan had served together at an earlier time, and the friendship between them had outlasted McLachlan's departure into marriage. The two women remained close. On the weekend of her death, McPherson was one of the two people left in the house at Sandyford Place, the family being away, and the old man James Fleming being the only other person in residence. It is important to fix the character of that friendship at the outset, because it is the emotional hinge on which the entire case turns. If Jessie McLachlan killed Jess McPherson, then this is a case of one friend killing another. If she did not, then she is a friend who was blamed for her friend's death and made to answer for it with 15 years of her life. The record does not permit a choice between those two accounts to be made with confidence, and the reader will be asked, at the proper place, to hold both of them in view. But the friendship itself is not in doubt. The two women knew one another well, had a history of shared service, and were together on the night that one of them died. They had been drinking together that night, a fact the record establishes and does not embellish. The circumstances of the household in the days before the death can be set down with some precision, for they became the ground on which the two competing theories were later fought. The Fleming family departed Glasgow for the weekend, leaving the house at 17 Sandyford Place in the keeping of the servant McPherson and the old father, James Fleming, aged 87. Old Fleming was a figure of some local standing and, as the trial would reveal, of some local talk. The silver plate belonging to the family remained in the house. Jessie McLachlan, living in the city in straitened circumstances, came to the house on the night of the 4th of July and into the early hours of the 5th. That she visited the house that night is a fact she never denied at any point in the proceedings that followed. What she disputed was not her presence, but her guilt. The old man's presence in the house across that whole interval is a fact of the first importance, and it must be stated carefully and without insinuation. James Fleming was 87. He was the only adult of the family in residence. He was alone with the servant McPherson for the days the family were absent, and he remained in the house through the night of the death and into the discovery that followed. The defence would later attack his character directly, making reference to a matter of church discipline concerning an illegitimate child said to have been fathered by him in his old age. That matter was raised by the defence and used against him, and the record treats it as documented, though the precise dates and the parish are not fixed here with full confidence. It must be understood as an allegation deployed in his cross-examination and not as a finding of any court. The narrator does not resolve what it meant. It is set down because the defence set it down, and because the credibility of James Fleming became, in the end, the whole contest of the trial. The night of the 4th of July, then, is the ground on which everything else stands. Jessie McLachlan came to the house at Sandyford Place in the evening. The two women were together in the basement. They had drink between them, and the hours passed, and at some point in the early morning of the 5th of July, Jess McPherson died in the servants' bedroom on the lower floor of the house. The cause of death is stated here once in the terms the record requires, and no others. Jess McPherson died of extensive blunt force injuries inflicted with a cleaver. Nothing further of the injuries is set down, for nothing further belongs in this account. She was 33 years old. She died in the room in which she slept, in a house otherwise occupied only by an old man and by the friend who had come to see her. The body was not discovered at once because the family was still away. In the interval between the death and the discovery, parts of the floors of the lower rooms were washed. When the Fleming family returned to the house, the servant was not to be found where she should have been, and the door of her room was locked. Old James Fleming, who had been in the house throughout, told the returning family that he had noticed nothing amiss, and that he had supposed the servant had gone out. The room was opened. The body of Jess McPherson was found within it. Silver plate belonging to the family was missing from the house, and some of the dead woman's own clothing was gone as well. The scene as the household came upon it admitted of no innocent reading. This was not a death that had been mistaken for a natural one, nor a body that lay as though sleep had taken it. From the moment the room was opened, everyone who saw it understood that a murder had been done in that house. That certainty is what makes the case unusual, and it is worth marking the difference plainly. In many cases of this kind, the whole labour of the investigation is to establish that a crime occurred at all, to convert a death first written down as natural into a death recognised as unlawful. Here there was no such labour. The crime declared itself. The only question from the first hour was who had done it, and the house offered exactly two people who had been within it when it was done. One was an 87-year-old man of a propertied family, resident in the house across the whole weekend. The other was a young working-class woman who had come to visit and had gone away again before the family returned. The investigation that followed was, in its entirety, the story of how suspicion moved from the first of these to the second. James Fleming was arrested first. That fact is often lost in the later tellings, and it should not be, for it is the beginning of the injustice question that the case has never been able to close. The old man had been in the house throughout. He was the person present, the person who could account for the days, the person whose word for what had passed was the only word available from within the walls. He was taken up and charged with the murder of Jess McPherson. Had matters rested there, the case would be remembered, if at all, as the trial of an old man. They did not rest there. James Fleming was released, and the charge against him was not pursued, and the machinery of the law turned instead toward the woman who had visited that night. The thing that turned it was a pawn ticket. In the days after the killing, a pawnbroker reported that the missing silver plate, or part of it, had been pledged with him by a woman who had given the name Mary MacDonald. The plate was traced, the name was false, and the woman behind the false name was found to be Jessie McLachlan, a former servant of the Fleming house and the friend of the dead woman. Here the two theories of the case divide, and they divide on a single question that was never resolved: whether McLachlan pawned the plate because she had stolen it in the course of a murder, or whether she pawned it, as she would afterwards say, at the direction of old Fleming, and under pressure to keep silent about what she had seen. The pawn ticket proved that she had handled the plate and had disposed of it under an assumed name. It did not of itself prove how the plate had come into her hands, nor what had happened in the room where its owner's servant lay dead. But it was enough to move the whole weight of suspicion from the old man to the young woman, and it did so quickly. The switch is the centre of the case and must be held in full view. An 87-year-old man, alone in a house for days with the woman who was killed in it, was arrested and then let go. A young working-class woman, present for part of a night, was then arrested and prosecuted to conviction and a sentence of death. The record does not establish that this was done corruptly, and it is not the narrator's place to say that it was. What the record establishes is the sequence, and the sequence is what has troubled every examiner of the case from that day to this. It is also worth setting down that this was the first case handled by the newly formed detective branch of the Glasgow police. The men who traced the pawn ticket and built the case against McLachlan were doing the work of a kind of policing that was itself new, and they were doing it, in this instance, for the first time. The investigation that produced the case against Jessie McLachlan is remembered for something more than the pawn ticket, and it is here that the case earns its place in the history of criminal procedure. The Sandyford murder is remembered as one of the earliest occasions on which photography was used as evidence in a British court, and the first Scottish police case in which forensic photography played a part. In the servant's bedroom, on the floor, there was a bloody print of a naked foot. Rather than lift it or trace it by hand alone, the investigators had the print photographed so that an image of it might be preserved and produced and compared. That decision, ordinary as it seems now, was novel then, and it is the strongest single reason the case is still spoken of in accounts of the modernisation of policing. To test the photographed print against the accused, the investigators took a print of Jessie McLachlan's own foot. The contemporary accounts describe the method with a plainness that the modern reader may find strange. Her foot was dipped in blood, said in the accounts to have been the blood of a bullock or a cow, and pressed upon a board, and the print so made was set beside the photograph of the print found at the scene, that the two might be compared. This was the science of the matter as it then stood. It was not the fingerprinting of a later age, nor anything with the authority such methods would later claim. It was a comparison of two shapes, one lifted from a floor by a camera, and one made by pressing an inked foot upon a board, and it was offered to a jury as a link between the woman in the dock and the room in which her friend had died. What the medical and forensic evidence could establish, and what it could not, is the pivot on which the fairness of the whole proceeding turns. The medical witnesses could establish the cause of death, and did. They could establish that the injuries were inflicted with a heavy-edged implement, and they identified the cleaver. They could speak to the blood found in the room and about the house, and to the washing of the floors, and to the print upon the boards. What none of this could establish was the identity of the hand that had struck. The blood in the room was the blood of a murder, but it did not carry a name. The footprint, even if it were McLachlan's, placed her foot in a room she had never denied entering. The washed floors testified to a concealment, but not to a culprit. And so the contest at the trial, when it came, turned less upon the cause of death, which was not seriously in dispute, than upon the interpretation of these things, and upon the credibility of the one living witness who had been in the house across the whole weekend. The forensic case, reduced to its parts, stood as follows. There was the plate, pawned under a false name, which tied McLachlan to the stolen goods. There was her clothing, which was recovered and found to be blood-stained, and which the Crown would make a plank of its case. There was the photographed footprint, offered as tying her foot to the room, and there was her own presence in the house that night, which she admitted. Against the weight of these things stood the fact that every one of them was consistent with the account she would eventually give, in which she was present, in which the killing was another's, and in which she had handled the plate and stained her clothing in the aftermath rather than in the act. The evidence was real, its meaning was contested. That distinction is the whole of the case, and it is the reason the case has never closed. Jessie McLachlan was arrested and brought before the authorities. In the course of the pre-trial procedure, she emitted a declaration dated the 21st of July, 1862, a formal statement taken down before the officers of the law and spoken to afterwards at the trial by William Hart, writer, who held the office of Procurator Fiscal in Glasgow. Scottish procedure of the period did not proceed by a coroner's inquest, as the English system did. There was no inquest jury sitting upon the body to return a finding of murder against a person or persons unknown. Instead, the investigation lay with the Procurator Fiscal, who gathered the evidence and took the declarations, and the accused underwent a judicial examination, and upon that basis an indictment was framed for trial at the Circuit Court of Justiciary. Her blood-stained clothing was recovered and retained as a production for the Crown. One consequence of that procedure deserves to be set down, because it bears directly upon the fairness of what followed. When James Fleming was released without trial, he did not simply pass out of the case. He re-entered it in another character altogether. The old man who had been arrested first for the murder of Jessie McLachlan became, upon his release, the principal witness for the Crown against Jessie McLachlan. The person once charged with the crime was now the person whose testimony would help to convict another of it. The defence would exploit that fact relentlessly, and it is not difficult to see why. A jury was to be asked to accept, from the mouth of a man who had himself been suspected, the account that fixed the guilt upon the woman in the dock. Whatever else may be said of the case, that arrangement placed a great weight upon the credibility of a single elderly witness, and the whole of the defence would be an attack upon that credibility. The trial of Jessie McLachlan opened at the Glasgow Circuit Court of Justiciary on the 17th of September 1862 and continued over 4 days, to the 20th. It was heard before Lord Deas, a judge whose reputation for severity toward accused persons was documented and known. The prosecution was conducted by Adam Gifford, Advocate Depute, assisted by Andrew Muir, Advocate. The defence was led by Andrew Rutherford Clarke, with Robert MacLean and Adam Bannatyne, advocates, appearing with him. The accused, who in the usage of the Scottish court was the panel, pleaded not guilty. It must be understood, in following what came after, that as a person accused in 1862, Jessie McLachlan could not give evidence upon oath in her own defence. She could not go into the witness box and tell the jury her account and be cross-examined upon it. Her version of events could reach the jury only through her declaration, taken before the trial, and, as it turned out, through the statement read aloud after the verdict. The woman most able to answer the case was, by the law of her time, the one person forbidden to speak to it directly. The Crown opened its case upon the plate. It was shown that the silver plate missing from the house at Sandyford Place had been pledged with a pawnbroker by a woman giving the name Mary MacDonald, and that the woman was Jessie McLachlan. The false name was made much of, for a person, with nothing to conceal, the Crown urged, does not pawn her friends' employer's silver under a name that is not her own. It was shown that she had been in want of money. It was shown that she'd been in the house on the night of the killing, a fact she did not dispute. The prosecution then turned to the clothing recovered from her and found to be blood-stained, and asked the jury to see in those stains the marks of the act itself. Piece by piece, the Crown assembled the picture of a woman present at the scene, in possession of the stolen goods, disposing of them under a false name, and bearing upon her clothes the blood of the crime. Then the Crown called James Fleming. The old man's evidence was the centre of the prosecution case, and the point upon which the defence had resolved to break it. Fleming told the court that he had been in the house across the weekend, that he had noticed nothing in the night, and that he had supposed the servant gone out. He placed McLachlan in the house. He denied any part in the death himself. Upon that testimony, the Crown rested its account of how the murder had been done, and by whom, and upon that testimony, Andrew Rutherford Clarke, for the defence, mounted his attack. The defence did not dispute that Jessie McLachlan had been in the house. It disputed that she had killed anyone. Rutherford Clark set out to show the jury that the man who had just given evidence against his client was himself the killer, and that the case against McLachlan was the case that ought to have been pressed against James Fleming. He drew the jury's attention to the plain facts of opportunity. Fleming had been alone in the house with the servant for days. He was the person present through the night of the death. He was the person who could give and could withhold any account of what had passed within those walls. The defence pressed upon the improbabilities in the old man's version, the things he claimed to have heard and not heard, the movements he described and could not explain, and the convenient completeness of a story that laid the whole weight of the matter upon a visitor who had come and gone. Rutherford Clark went further and attacked the old man's character directly. He brought before the court the matter of church discipline concerning an illegitimate child said to have been fathered by James Fleming in his old age, a matter documented and pressed in cross-examination, though it was an allegation raised against a witness and not a finding of any court. The purpose was plain. If the jury could be brought to see the principal Crown witness, not as a frail and blameless old man, but as a person of concealments and appetites, capable of conduct he would not own to, then his account of the night might be doubted, and with it the whole of the Crown's construction. The defence held that McLachlan had been present in the house, but was not the killer, and that the person who had struck Jess Macpherson was the man who had been left alone with her, and who now stood in the witness box accusing another. The contest between the two accounts could not be resolved by the medical witnesses, and this is the deepest difficulty of the trial. The physicians and the men of science spoke to the cause of death, which was not in dispute, and to the blood, and to the print upon the boards. They could say how Jess Macpherson had died. They could not say by whose hand. The photographed footprint was laid before the jury, and the print taken from McLachlan's foot was set beside it, and the jury was invited to see a correspondence. But even a perfect correspondence would prove only that her foot had touched the floor of a room she admitted entering. The blood-stained clothing was laid before the jury, but bloodstains upon the clothes of a woman who was present in the house when a killing was done, and who by her own later account had been in the room afterwards, did not by themselves declare whether she had struck the blows or come upon their aftermath. Every physical fact the Crown produced was consistent with guilt. Every one of them was also consistent with the account the defence pressed. The evidence pointed to the scene. It did not point to the hand. When the evidence was concluded and counsel had addressed the jury, Lord Dias delivered his charge. The summing up ran for more than 4 hours, and it was afterwards widely criticised as hostile to the defence and as amounting, in effect, to a direction to convict. The judge, who had a documented reputation for severity, brought that severity to bear in the last address the jury would hear before they retired, and contemporaries recorded their sense that the scales had been weighted from the bench. Whatever the justice of that criticism, its consequence in the room was not long in showing. The jury retired to consider its verdict. They returned in 19 minutes. The verdict was unanimous, and it was guilty. It should be marked that in Scotland the jury had a third course open to it, the verdict of not proven, which is neither a conviction nor an acquittal, but the law's declaration that the case has not been made out. That course was available to the jury that tried Jessie McLachlan, and the jury did not take it. It did not find the case unproven. It found the panel guilty of murder, and it did so after 19 minutes. Upon evidence that 4 days had not sufficed to make certain, and after a charge from the bench that had run 4 hours against her, there followed the moment upon which the whole afterlife of the case turns. Before sentence was pronounced, McLachlan's counsel obtained the leave of the court for a long written statement, prepared by the prisoner to be read aloud in open court. This was unusual, and it was permitted, and it changed everything that came after. In that statement, Jessie McLachlan gave, for the first time in the proceedings, a connected account of the night, its substance as the record preserves it, and, as it must be reported here without invented quotation, was this. She had been present in the house. She had not killed her friend. It was old James Fleming who had struck Jess McPherson. She had been in the house when it was done, and afterwards she had been pressed and paid to keep silence, and it was at Fleming's direction that she had taken the plate and pawned it under the false name. The account offered a coherent alternative to the Crown's, one that fitted the physical facts as well as the Crown's own theory fitted them, and it was heard for the first time only after the jury that might have weighed it had already returned its verdict. Lord Dias pronounced the sentence of death. The execution was fixed for the 11th of October, 1862. The judge dismissed the account the prisoner had given, and the law, having found her guilty, prepared to carry out upon her the last penalty it possessed. Had the ordinary course been followed, Jessie McLachlan would have been hanged in Glasgow within the month, and the reading of her statement would have been the last thing the public heard from her. That is not what happened. The reading of the statement had done something the trial itself had not. It had put before the public a full and connected account from the woman condemned, and that account, printed and circulated in the press, produced an immediate and mass reaction in Glasgow and far beyond it. The sympathy was not confined to the city where the killing had happened. It ran through the national press, which took up the case and pressed it, and it gathered into a public campaign of a kind that the authorities could not ignore. A petition was raised on her behalf. The newspapers argued the matter day upon day. The sense abroad in the country was that a young working-class woman was to be hanged upon evidence that had not been made certain, while an old man who had been arrested first and against whom a coherent case had been laid by the defence, walked free and had given evidence to condemn her. The public did not accept the verdict as settled, and it did not accept the sentence as just. Under the pressure of that campaign, the Home Office took a step that was unusual and close to unprecedented. It appointed a special commission of inquiry to examine the safety of the conviction. This was not an appeal in the sense that a later age would know, for the machinery of criminal appeal did not then exist in the form it would later take. It was an extraordinary intervention, a review from outside the court of a verdict a jury had returned, and its very existence was a measure of how far the public revolt had reached. A commissioner was charged to look into the case, to hear what could be heard, and to advise upon whether the sentence of death ought to be carried out. The inquiry did not do what the campaign had hoped, and it did not do what the Crown had done. It did not exonerate Jessie McLachlan. It did not declare her innocent, and it did not clear old James Fleming, and it did not name him as the killer in her place. It reached no finding that resolved the question of who had struck Jess McPherson. What it did was to conclude that the sentence of death should not stand. The result of the commission was the commutation of that sentence to penal servitude for life. The execution fixed for the 11th of October did not take place. Jessie McLachlan did not hang, nor was she set free. The law having convicted her and then having been forced to look again at its own conviction, settled in the end upon neither answer, and left her convicted but not executed, doubted but not delivered. That outcome is the reason the case is remembered as it is, and it should be marked precisely, for its ambiguity is the whole of it. A jury had found her guilty in 19 minutes. A judge had sentenced her to death. A public campaign had forced a review no ordinary case received, and that review had refused both to hang her and to clear her. The conviction remained upon the record. The doubt remained upon the conviction. The one thing the whole extraordinary process had not produced was certainty, and it is that absence of certainty, formally acknowledged by the commutation itself, that has kept the case alive. Jessie McLachlan passed from the condemned cell into penal servitude, and there she remained for the better part of 15 years. The record of those years is not full, and it should not be filled by invention. She served her sentence. She maintained throughout that she had not killed her friend, and that the account she had given in her statement was the true one. She was released upon a ticket of leave on the 5th of October, 1877, having served roughly 15 years of the life sentence to which her death sentence had been reduced. She did not return to the life she'd known before. She is reported to have emigrated to the United States and to have remarried there, though the particulars of that later life are thin and are not established with confidence. What the record does fix is that she died in Port Huron in the state of Michigan on the 1st of January 1899, and that to the end she held to her innocence. The other figure at the centre of the case passed into obscurity. James Fleming was never tried for the murder of Jess McPherson. He had been arrested first and released, and he had given evidence as the Crown's principal witness, and after the trial he returned to a private life, of which the record preserves little. The date of his death is not fixed here with confidence. He was never charged again, and he was never cleared by any court, for no court ever sat to consider the case against him after the defence had raised it. The man whom the defence had named as the killer, and against whom a coherent argument had been laid before a jury, lived out his remaining years without the law ever returning to the question. That, too, is part of what has unsettled every later examiner of the case. The verdict, then, is the engine of the whole matter, and it must not be resolved here because the record does not resolve it. Two people were alone in the house at Sandyford Place across that weekend: Jess McPherson and James Fleming. Jessie McLachlan came to the house on the night of the killing and never denied it. She was the one convicted. Fleming was released and never tried. The case that can be made for her guilt is real and must be stated in full. She was present in the house that night. She pawned the household plate under a false name. Her clothing was found to be blood-stained. The photographed footprint was matched to her foot, and the old man's testimony placed her at the scene. Her jury heard those things and convicted, and no honest account can pretend the Crown had nothing. The case that can be made against her guilt and for reasonable doubt is equally real and must be stated with equal weight. James Fleming alone had the sustained days-long sole opportunity that the crime required. He was arrested first before suspicion turned. His character was compromised by the matter the defence raised against him. He became the Crown's own witness, condemning another of the very act for which he had first been taken up. The summing up that preceded the conviction was widely judged unfair. Her statement offered an account that fitted the physical facts as fully as the Crown's did, and the trend of opinion over the long years since has hardened steadily toward her innocence. Yet the record does not prove that Fleming did it. It proves that he had the opportunity, that his character was questioned, and that his account was doubted. It does not put the cleaver in his hand any more than it puts it in hers. The case declines to convict either of them, and so must any account faithful to it. Over the century and more that followed, the Sandyford Place murder became one of the enduring puzzles of Scottish criminal history. It was drawn into the small company of Glasgow cases that fixed themselves in the national memory, and it found its most lasting frame in Jack House's book Square Mile of Murder, published in 1961, which set McLachlan's case alongside three other killings of the Glasgow West End, those associated with Madeline Smith, with Dr. Pritchard, and with Oscar Slater, and gathered them into a single geography of infamy within a few streets of one another. House framed McLachlan's case as one of injustice, and his telling carried that framing to a wide readership. In the decades that followed, the case drew books and essays, the attention of podcasts and of a series reproducing the contemporary trial in full, and treatment on television, and it was argued and re-argued as a study in class in the novelty of forensic method and in the overreach of a judge. The direction of that long reconsideration has been steady and in one direction. Opinion has moved further and further toward McLachlan's innocence and toward the censure of Lord Dias, and yet no reconsideration, however sympathetic, has been able to prove James Fleming guilty, and the honest verdict of history remains the open one it was on the day the Commission declined to answer. The institutional marks the case left behind are the firmest thing about it, and they justify the place it holds in the history of the law's modernisation. The Sandyford case stands among the earliest occasions on which photographic evidence was placed before a British court, the photographed print upon the floor being produced and compared as an image rather than merely described. It was the first case handled by the newly formed detective branch of the Glasgow police, an early exercise of a kind of investigation that was itself only then coming into being. And the public campaign that forced the Home Office to appoint a special commission into the safety of a jury's verdict was a striking early instance of the review of a conviction from outside the court that convicted, foreshadowing the appeal mechanisms that a later age would build into the ordinary structure of criminal justice. These three things, the photograph, the detective branch, and the commission of inquiry, are the durable legacy of a case whose central question was never settled. The social frame in which all of this occurred is worth setting down at length, because the case cannot be understood apart from it, and because the record supplies the material to do so without invention. The Glasgow of 1862 was a city of sharp and visible division, its wealth gathered in the western terraces, and its labour housed in the closes and tenements that pressed close upon them. The genteel row at Sandyford Place belonged to the first of these worlds. It was a street of professional men and their families, of accountants and merchants and their like, and its respectability was maintained, as such respectability always was, by an economy of servants who lived within the houses and yet apart from the families they served. These were the women who rose in the dark to lay the fires, who carried the coal and the water, who slept in the basement rooms below the level of the street, and who were, for the most part, invisible to the world above the stairs. Jessie McLachlan had lived in that condition, and Jessie McLachlan had lived in it before her marriage, and it was in that condition that the two women had first come to know one another. The invisibility of the servant is not merely a matter of sentiment. It bore directly upon the case, because it shaped the whole question of credibility on which the trial turned. When suspicion had to choose between an 87-year-old man of a propertied family and a young woman of the servant class holding a pawn ticket, the choice was not made in a vacuum. It was made in a society that granted to the one a presumption of standing and respectability that it did not readily grant to the other. The old man belonged by birth and by family to the world above the stairs. The young woman belonged to the world below them. The propertied household, confronted with a killing under its own roof, would look last of all to one of its own, and the direction in which the law finally moved followed the grain of that expectation. The record does not say that this was decisive. It says that this was the ground upon which the decision was made, and no account of the case is complete that leaves it out. The position of Jessie McLachlan as a married woman bore upon her circumstances in ways that the modern reader must be told plainly, for the law of her time is not the law of ours. In 1862, a married woman in Scotland, as in England, occupied a dependent legal position that the reforms of the following decades would only begin to alter. The Married Women's Property Acts, which would grant to a wife a separate legal existence in respect of her own earnings and property, lay years in the future, the first in 1870 and the fuller measure in 1882. In 1862, a married woman had no such separate standing. Her husband was a seaman, often absent, and his wages came intermittently, and in the intervals a woman kept her household as she could. The pawn shop was, for a woman in that position, not a mark of criminality, but an ordinary instrument of survival, a place where goods were turned into money in a hard week and redeemed, if fortune allowed, in a better one. That McLachlan knew her way to a pawnbroker was not, of itself, remarkable in a woman of her class and situation. What was remarkable, and what the Crown pressed, was the false name and the ownership of the plate, but the familiarity with pawning, taken alone, told only that she was poor. the figure of the working-class woman in the dock, before the mid-Victorian press, is the last of the frames the case requires, and the trial and its aftermath show that figure in both of its aspects. On the one hand, such a woman entered the courtroom at a disadvantage, without the presumption of respectability that protected her betters, unable by the law of the time to speak upon oath in her own defence, and dependent upon counsel to make her case for her. On the other hand, the same press that might have condemned her became, in this instance, the instrument of her rescue from the gallows. When her statement was read and printed, the public that read it did not see a servant to be disbelieved. It saw a young woman condemned upon uncertain evidence, while an old man went free, and it rose on her behalf with a force that reached the Home Office and stayed the hangman's hand. The press that could destroy could also deliver, and in the case of Jessie McLachlan, it delivered her from death, though not from doubt, and not from the 15 years. There is a further dimension to the case that belongs to the history of the law itself, and it concerns the manner in which the accused was silenced, and then by an accident of procedure allowed to speak. By the rule of 1862, the panel could not give evidence upon oath, and so through all 4 days of the trial, the one voice most able to answer the Crown was the one voice the court would not hear directly. Her declaration, taken before the trial, was spoken to by the Procurator Fiscal, but a declaration is not a defence given and tested in the box. The extraordinary thing about the Sandyford case is that the leave granted to read her statement after the verdict opened, for a moment, the door that the law had kept shut, and the account that the jury had been denied during its deliberation reached the public the moment the deliberation was over. The reform that would in time allow accused persons to testify in their own defence lay decades ahead. The case stands as one of the vivid illustrations of what the older rule cost, for the statement that moved a nation to petition on her behalf was the very account the jury that condemned her had never been permitted to weigh. The washing of the floors, the locked door of the servants' room, the family returning to a house that had kept its secret through a summer weekend, the pawnbroker turning over in his mind the woman who had given a name that did not fit her, the detective branch tracing a ticket through the shops of the city, the old man in the witness box and the young woman in the dock who could not answer him, the judge speaking for 4 hours and the jury returning in 19 minutes, the statement read into a silent court and printed into a roaring press, the commission that would neither hang her nor free her, the 15 years, the ticket of leave, the passage across the Atlantic, and the death in a Michigan town on the first day of a new year. These are the documented stages of the case as the record preserves them, each one attested, each one certain in itself, and yet the sum of them declining to yield the single fact that all of them circle, which is the name of the hand that struck Jess McPherson in the basement of the house at Sandyford Place. The parts are known. The whole is not. That is the peculiar condition of this case, and it is the condition in which it has remained from the day the Commission reported to the present hour. It is worth dwelling for a moment longer on what that condition means for anyone who comes to the record now. A modern reader, accustomed to the idea that evidence accumulates until it settles a question, arrives at the Sandyford papers expecting that somewhere within them the answer waits to be found, that with enough patience the transcript will yield up which of the 2 people in that house lifted the weapon. It does not. The transcript is full, the counsel are named, the medical testimony is preserved, the declaration survives, the statement survives, the commutation is recorded in the plainest terms, and still the centre of it is empty. Every document points inward toward the basement room and stops at its threshold. What happened inside it in the early hours of the 5th of July was witnessed, at most, by 2 people, one of whom died there, and one of whom went to the grave, decades later, without ever standing trial. The record can carry a reader to the door of that room, and no further. That is a rarer thing than the sheer notoriety of the case might suggest. Many contested Victorian trials turn on a shortage of evidence, on a gap that later discovery might, in principle, have filled. The Sandyford case is not of that kind. It does not suffer from too little evidence, but from evidence that will not resolve, facts that are certain in themselves and mute as to the one thing that matters. The plate was pawned, that is certain. The name was false, that is certain. The clothing was stained, that is certain. The foot was pressed and the print compared, that is certain. The floors were washed, that is certain. And every one of those certainties can be fitted without strain into either of the two stories the case has always offered: the story in which a friend killed a friend and covered it, and the story in which a friend came upon a killing and was made to carry it. The evidence is not silent. It speaks in two voices at once, and it has never chosen between them. The people who lived it are all long gone now, and each of them carried out of the case a portion of its unresolved weight. Jess McPherson carried it into a grave she went to as the victim of a murder that was proved to have happened and never proved as to its author. Jessie McLachlan carried it across an ocean, and through the second half of a life the record barely follows, holding to a single account for the whole of that time, and dying with it unretracted in a town far from the terrace where the trouble began. James Fleming carried it into an obscurity so complete that the record cannot say with confidence when it closed over him. A man named before a jury as a killer, and never once required by any court to answer the naming. Lord Deas carried it as the judge whose 4 hours from the bench became, in the long reconsideration, the very thing the cases used to warn against. Each of them is fixed now at the position the case left them in, and none of those positions has moved in more than a century and a half. And so the whole of it comes to rest, as it always has, on the discovery in the basement, and the two people who might have accounted for it. One silenced by death, and one silenced by the law, until the moment her silence could no longer change the verdict. The house at Sandyford Place still stands in the western terraces of Glasgow, and the papers of the trial are still there to be read, and the photograph that was novel then is still counted among the first of its kind. What is not there, and never was, is the answer. The Commission looked for it, and declined to state it. The century that followed looked for it, and could only lean toward one side without ever reaching it. The record holds everything about the case, except the single fact the case exists to determine, and it holds that absence as steadily as it holds all the rest. Consider what that steadiness actually asks of the reader who takes the case up in good faith. It asks a suspension that the mind resists, because the mind wants to close what it opens, and the case will not permit the closing. To read the Sandyford papers honestly is to hold two people at once in the frame of a single killing, and to refuse the relief of putting the weapon in either hand, and to keep refusing it not because the material is thin, but because the material, weighed as fairly as it can be weighed, comes out even. That is an uncomfortable place to be left, and the discomfort is precisely why so many who have written on the case have reached, in the end, for a verdict of their own, leaning toward the woman and away from the old man, giving to their sympathy the office that the evidence declined to fill. The leaning is understandable, and it is well founded in the unfairness of the trial, but it remains a leaning, an act of judgment laid over a record that does not itself contain the judgment. The figures, set out plainly, hold the whole shape of it. Two people alone in one house across the better part of 3 days. One night on which a visitor came and went. One death, discovered when the family returned. 2 arrests, the first of the old man and the second of the young woman. 4 days of trial, 4 hours of charge from the bench, 19 minutes of deliberation. 1 verdict of guilty, where a verdict of not proven stood ready and untaken. 1 sentence of death, fixed for a day in October that never came. 1 statement read aloud too late to be weighed. 1 petition, 1 commission, 1 commutation. 15 years of penal servitude. 1 ticket of leave in the autumn of 1877. 1 passage across the Atlantic. 1 death on the first day of 1899 in a town in Michigan. Every number in that sequence is fixed and certain, and the sequence as a whole still turns upon a fact that no number in it supplies. That is the account the record permits, set down as far as the record will carry it, and no further, with the two stories held level, and the single question left where the commission left it. What can be told has been told. What cannot be told is the one thing the case was ever about, and the honest close is to say so and to stop where the evidence stops. There is a discipline in that stopping which the case itself seems to demand, and it is the same discipline the surviving record keeps. The papers do not editorialize the missing fact into place. The transcript records what was said and does not supply what was not. The commutation names a reduction of sentence and does not name a culprit. The pattern of the whole surviving material is a pattern of restraint, of documents that go exactly as far as their knowledge and refuse the last inch. And any faithful retelling must keep the same restraint, or it ceases to be a retelling and becomes an invention. It would be the easiest thing in the world to give this account a resolution, to choose the door and open it and put a figure on the other side of it. The record does not do that, and so this account does not do that either. What remains, then, is a woman who spent the second half of her life in a country not her own, keeping to one account of a single night until the day she died. A servant who was never anything but the victim of a crime that was proved against no one to the standard the law required. An old man who was named and never tried and never cleared, and a conviction that a jury returned, a public rejected, a commission would not endorse, and history has never been able either to overturn or to trust. Those four things sit together and do not reconcile, and they have not reconciled in all the years since the commission reported. The case gave the law a photograph in evidence, a detective branch its first work, and a verdict its first extraordinary review, and it kept for itself the one thing none of those advances could reach. And that is where the matter settles, if settling is even the word for it, upon a stillness rather than an answer. The photograph fixed a shape upon a floor and could not fix a name to the foot that made it. The detective branch traced a ticket through the pawn shops of a great city and could not trace the hand that had earned the plate its blood-stained journey. The commission gathered what could be gathered and could not gather the single certainty that would have justified either mercy or execution on its merits, rather than on doubt. Each of the three novelties for which the case is remembered performed exactly the work it was built to perform, and each of them stopped short at the same boundary, the boundary of the locked room in the basement and the small hours of a July morning. The instruments improved, the reach of the law lengthened, the public conscience found a voice it had not known it possessed, and the question at the heart of it stayed exactly where it had been from the moment the door was opened and the body found within. A young woman went to a house to see a friend, and the friend was dead by morning, and the law that followed could establish everything about that night, except who had done the thing that made it a crime. She was convicted, and she was condemned, and she was spared, and she lived out her years an ocean away, insisting she was not the one. And no court ever contradicted her, and no court ever cleared her, and the old man who might have answered never had to. The record holds them there together, the accused and the victim and the man who was let go, in a balance that no weight has ever tipped. It is a balance made of particulars, and the particulars are what keep it from ever becoming abstract. There is the plate itself, ordinary domestic silver of the kind a professional household kept and used, carried out of the house and laid upon a pawnbroker's counter and pledged for money by a woman who gave a name that was not hers. There is the counter and the broker's ledger and the false name written into it, a small deception of the sort a hard week might prompt, and a murder might equally require, and no reading of the ledger alone can tell which it served. There is the board on which a foot was pressed, and the blood of a beast used to make the mark, and the photograph laid beside it, two images of one shape offered to 12 men, as proof of a presence the woman had never troubled to deny. There is the clothing, folded away as a production of the crown, stained in a manner consistent with striking and consistent with the aftermath of another's striking, and silent as to which. Every object in the case is like that. Each one is real, each one was produced and examined and argued over, and each one holds its meaning suspended between the two accounts. The house at Sandyford Place holds it, the basement room holds it, the washed floors hold it, even the 19 minutes hold it, for a jury that quick left no room to suppose it had wrestled with the doubt that the 4 days had raised, and the speed of the verdict became, in time, part of the evidence against the verdict. The parts remain exact and countable and mute, and the sum they were meant to make has never been made. There is one last way of measuring the case, and it is the measure of the years themselves. From the summer of 1862 to the release in the autumn of 1877 is 15 years, and those 15 years were served by a person who never once in all that time altered the account she had given on the day she was condemned. That constancy is itself a fact of the record, neither proof of innocence nor evidence of guilt, but a thing that happened and can be stated. A guilty woman might hold to a lie for 15 years, and an innocent one might hold to the truth for the same span, and the holding looks identical from the outside. The record can tell us that she held, and cannot tell us which of the two it was that she was holding. Even her endurance, the one long unbroken thread that runs from the condemned cell to the town in Michigan, refuses to resolve into an answer, and joins instead the great body of certain particulars that surround an uncertain centre. From the far side of all of it, the case looks less like a puzzle waiting to be solved than like a fixed monument to the limits of what proof can do. It was assembled with the newest instruments its age possessed, argued by able counsel on both sides, judged from a bench of long experience, tried by a jury of the woman's contemporaries, reviewed by the state at the height of a public clamour, and it delivered, at the end of all that machinery, a woman convicted and unhanged, a suspect freed and unexamined, and a victim mourned and unavenged in law. The machinery worked. The people within it did, for the most part, what their offices required. And still the thing at the centre would not come clear, and has not come clear, and by every honest reckoning is not going to. And that is the last measure, the plain endurance of the not knowing itself, which has outlasted every person who touched the case and every instrument that was brought to bear on it. The photograph has faded into an artifact of legal history. The detective branch has grown into a settled institution. The rule that kept the accused from the witness box has long since been swept away, and the extraordinary commission has been succeeded by ordinary courts of appeal that sit as a matter of course. All the novelties aged into commonplaces. Only the silence at the centre of the Sandyford case stayed exactly as new as it was on the morning the room was opened, undiminished by any of the advances that grew up around it, as certain now as it was then that two people knew what happened in that basement, and only one of them ever spoke, and she spoke to a court that had already decided not to believe her. So the record closes as the record opened, upon a death that was plainly a crime, and a crime that was never plainly assigned. The friend who came in the night, the friend who died before morning, the old man in the house, the plate on the counter, the print on the board, the 4 hours and the 19 minutes, the statement and the petition, and the commission, and the 15 years, and the long American silence at the end of it. All of it is known. The one thing that would make sense of all of it is not. To sit with that for a moment is to understand why the case has never let go of those who study it. It is not the horror of the killing, which the record keeps deliberately plain, and it is not the fame of the names, for the names outside Scotland are little known. It is the particular quality of a case that gives you everything and withholds only the centre, that lays out its evidence with generosity and then declines the conclusion the evidence seems to promise. Most stories of crime move toward a settling. This one moves toward a suspension and stays there, and the mind that follows it is left holding the same open question the commissioner held, the same question the jury was asked and answered too quickly, the same question the woman carried across the ocean and the old man carried into his obscurity. Who struck Jessie McLachlan in the basement of the house at Sandyford Place? The case was built to answer it. It never did. Everything that could be documented was documented. The eligibility of the facts, the names of the counsel, the dates of the trial, the terms of the sentence, the fact of the commutation, the year of the release, and the year and the place of the death, all of it is fixed and verified and stands. What is not documented because it could not be is the act itself, and no honest account will pretend otherwise. The surviving record carries the reader precisely as far as the evidence goes, sets down the two accounts in equal weight, and stops at the threshold the evidence never crossed. It is worth naming, before this account leaves her, the plain human shape of what those verified facts amount to for the woman at the centre of them. She was in her late 20s when the door of the condemned cell closed on her, a wife and a mother with a young child and a husband at sea, and she was past 40 when the ticket of leave let her out. The child grown in her absence, the marriage and the household she had kept dissolved into the years she had lost. 15 years is not an abstraction when it is measured against a single life. It is the whole middle of that life, taken and not given back, spent in the labour and confinement of penal servitude on a conviction that the state itself had refused to trust enough to carry to its end. Whatever the truth of the night, that price was paid in full, in the only currency a person has, which is time, and no commutation and no later sympathy ever returned a day of it. And when the confinement was over, she did not stay to be pointed at in the city that had condemned and then championed her. She crossed the Atlantic and made what life she could in a country where the name Sandyford meant nothing, and she carried her account of the night with her the whole way, unchanged, into a town on the American shore of a great lake. And there, on the first day of a new year, at the very turn of the century that had tried her, she died. The record follows her that far and sets her down, an old woman a long way from the basement in Glasgow, still saying what she'd always said, and it asks the reader to leave her there without the verdict she was never given, and the exoneration she never received. That is as far as the road runs for her, and the record, having brought her to the end of it, keeps its silence about what lay behind the account she never abandoned. It does not tell us whether the constancy was the constancy of the truthful or the constancy of the resolved. It tells us only that it held from the cell to the lakeside, through 15 years of servitude and 20 more of exile, unbroken to the last day. A lesser telling would seize on that endurance and make it speak, would read innocence into the steadiness of a woman who never wavered, or read cunning into the same steadiness, and call it the discipline of a practiced lie. The record permits neither reading to close, and so this account permits neither. It sets the constancy down as the final documented fact about her, and declines to translate it into a verdict, because translation would be invention, and invention is the one thing forbidden to an account that means to be faithful. So the two women who began in the same house, serving the same family, come at last to their separate ends, within the compass of a single, unanswered question. One of them died in a basement in Glasgow in the summer of 1862, murdered by a hand the law could name, to no one's certain satisfaction. The other died in a town in Michigan on the first day of 1899, an old woman still insisting on her innocence. 37 years, and an ocean removed from the room where their friendship ended. Between those two deaths lies everything the record holds, and the one thing it does not, and the distance between them is the exact shape of the case. That distance can be counted in more than years and miles. It can be counted in all the things that stood between the two women at the end, which had not stood between them at the beginning. At the beginning they were two servants, in one house, equals in station, near equals in age, bound by the ordinary intimacy of shared work and shared hours. By the end, one of them was a name in a murder that founded a chapter of legal history, and the other was the woman forever attached to that name as either its author or its scapegoat. The friendship that had been a private thing between two working women became, against the will of both, a public matter argued in a courtroom, printed in newspapers, weighed by a commission of the Crown, and set down in a book that fixed it for later generations. Neither of them chose that. One of them was dead before it began, and the other was carried into it against everything she said. The case took a friendship and made it evidence, and the record has kept it in that altered form ever since, so that the two women can no longer be thought of apart from the question of which of them wronged the other, if either did. There is a hardness in that which the plainness of the record does not soften. Whatever else the Sandyford case took from the people caught in it, it took from those two women the simple fact of their friendship as a thing that had belonged to them alone. After the summer of 1862, it belonged to the courts and the papers and the long argument of history, and it has never been returned to the private keeping in which it began. That is among the quieter costs of the case, and it is a real one, and it sits alongside the 15 years and the unanswered question as part of what the record, faithfully read, is obliged to hold. And it is obliged, too, to hold the plainest truth of all beneath the argument, which is that a woman was killed. Underneath the questions of forensic novelty and judicial fairness and class and credibility, underneath the long reconsideration and the institutional firsts, there was a death, and the death was real, and the person who suffered it was not a case but a woman who had risen that morning and gone about her work and expected to rise again. Jess McPherson was not a puzzle. She was a domestic servant of good standing, with her own friendships and her own place in the world, and she died in the room where she slept, and the crime against her was never answered to the standard the law required. Everything else the case became grew up over that fact, and the fact remains at the bottom of it, plain and unavenged. No account faithful to the record should let the interest of the questions obscure the weight of that, nor should it let the sympathy that gathered around the accused erase the truth that the sympathy did not amount to proof. The public that rose for Jessie McLachlan rose against an injustice it could feel, the injustice of a swift verdict and a hostile bench and an old man let go, and it was right to feel it. But feeling an injustice in the manner of a conviction is not the same as knowing the innocence of the convicted, and the campaign that saved her from the rope never claimed to have established what happened in the room. It claimed only that the case had not been proved to the certainty that a hanging demands, and in that narrower claim it was vindicated, for the state itself, looking again, declined to carry the sentence out. That is the whole of what was won. It was a great deal. It was not an answer. To hold both of those truths at once, the reality of the death and the insufficiency of the proof, is the discipline the case demands, and the discipline it has most often been denied. It is easier to take one and drop the other, to remember the victim and forget that her killer was never established, or to remember the injustice to the accused and forget that a woman lay dead at the root of it. The record will not allow either forgetting. It keeps the death and the doubt in the same frame, the murdered servant and the convicted friend and the unexamined old man, and it insists that any account which drops one of them for the comfort of a cleaner story has ceased to be true to what happened. There is no clean story here. There is a death that was certainly a murder and a conviction that was never certainly just, and they belong together, and the honest reader carries both. That is the whole of what the record establishes and the whole of what it withholds, and the two are inseparable, and neither has moved in the long century and a half since the Commission laid down its pen. The case is complete in every part except the one part that would complete it. It is, in the end, exactly what it was on the morning the room was opened, a certain crime and an uncertain hand, a friendship ended, and a question left standing. Everything known, and the one thing unknown, held together in a balance that time has not tipped, and evidence has not resolved, and no faithful telling has any right to force. That balance is the thing the case bequeaths, more durable than any of its firsts, and it asks something of everyone who takes it up. It asks patience with a question that will not close, and honesty about the limit of what can be known, and a refusal of the easy relief of choosing a culprit the evidence does not name. Those are not the ordinary rewards of a criminal history, which usually offers the satisfaction of a solved thing, a name pinned to a deed, a matter put to rest. Sandyford offers instead the harder education of a matter that cannot be put to rest, and it offers it through a real death and real people and real years served, so that the lesson is never abstract and never comfortable. The house still stands, the papers still read, the question still waits, and the only faithful posture before it is the one the commission was forced into, and the one this account has kept throughout, which is to lay out everything that is known, to weigh the two accounts without deciding between them, and to leave the centre where the record left it, unfilled. For in the end, the surviving record does not offer a solution, and it never pretended to. It offers a woman accused, a woman dead, an old man freed, a trial, a verdict, a reprieve, and a silence at the heart of all of it that no instrument of that age or this has been able to break. What can be set down has been set down. What cannot be known remains unknown, and the record keeps it so. And what the record keeps, it keeps without decoration. There is no flourish in the papers, no summation that reaches for the answer the evidence denied. The declaration of the 21st of July stands as it was taken. The productions stand as they were lodged. The charge from the bench stands as it was delivered, 4 hours of it, and the verdict stands beside it, 19 minutes, and the commutation stands after both, undoing the sentence without undoing the conviction. Read in sequence, the documents do not build toward a revelation. They build toward the exact suspension in which they have always rested, each one adding its certain particular to a sum that stays uncertain. That is not a failure of the record. It is the record being honest about the boundary of its own knowledge, and it is the reason the case can be told at all without the telling becoming a lie, a death that was plainly a crime, a friend accused of it and convicted in haste, an old man named and never tried, a sentence of death commuted under the weight of a public that would not have it carried out. 15 years served by a woman who never changed her account, and a quiet death at the far end of them in a country not her own. Around that a scaffolding of firsts, the photograph and the detective branch and the extraordinary inquiry, each real, each lasting, none of them able to reach the fact they were raised around. This is the case as the record gives it, entire in all its parts, and open at its centre, and open it remains. It stays open in the one place it has always stayed open, the small hours of the 5th of July, in a basement room in a house on a genteel terrace, where a woman was struck down, and only 2 people could have known by whom, and where the record, for all its fullness, has never been able to follow. That is the room every account of the case circles, and none can enter. The camera reached the floor of it and photographed a print. The counsel reached the edges of it and argued for 4 days. The commission reached over it and stayed a hanging. But the moment itself, the act that made all the rest necessary, lies beyond the reach of every document that survives, sealed inside a night that ended before anyone but the dead and the living witness could see into it, and neither of those 2 ever gave the account that would have settled it. The one because she could not, and the other because she was believed by too few and heard too late. So the balance holds, as it has held from the beginning, weighted equally and tipped by nothing. A woman convicted, and a woman dead, and a man let go, and a question standing over all 3 that the fullest record in Scottish criminal history has never once been able to answer.